Are we still waiting for anyone, Mr. Secretary, or are we all here?
Looks like we're just waiting on Commissioner Montemayor. Here he is. I'll admit him now. Looks like we're all here.
Okay. I still don't have a full screen, so I wasn't sure. Are we still sharing your screen, Roger?
I don't believe so.
That's what I've got. I've got some of us on the top, and I've got secretary on my whole screen.
Okay, let me try to share and unshare again.
Okay, let's see.
Did that work?
Okay, that's yes.
Awesome.
Okay. All right. This time I would like to call the meeting to order. Today's Thursday, October 28th, 2021. And this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. Commissioner Kerpes, would you be so kind as to lead us in the Pledge of Allegiance, please?
Sure. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty
and justice for all.
Thank you. Mr. Secretary, may we have a roll call, please?
Yes, Commissioner Ayers.
Here.
Commissioner Kerpes.
Here.
Commissioner Maggio.
Here.
Commissioner Montemayor.
Here.
Commissioner Topshin.
Here.
Acting Chair Copeland.
Here. And we have a quorum. Yes. Next, we have the approval of the agenda. Are there any changes to the agenda for tonight? Seeing none.
Motion to approve.
Do we have a motion to approve?
I'll second that motion.
All right, we have a motion and a second to approve the agenda. May we have a roll call vote, please?
Commissioner Ayers.
Aye.
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Commissioner Montemayor.
Aye.
Commissioner Topshin.
Aye.
Acting Chair Copeland.
Aye, and the motion passes. Next up is the approval of the minutes from our meeting of October the 14th, 2021. Has everyone had a chance to review the minutes?
Madam Chair, I have an amendment.
Okay,
On page 2, under 10, unfinished business, I guess under A, where it talks about the second sentence, Commissioner Kerpes expressed his concern with limiting the hearing examiner's ability to consider whether, do you see where that's at?
yes,
So actually, so ability to consider whether housing service was lost or not, depending on the legality of the service. It actually should read expressed his concern, expressed his support for limiting hearing examiner's ability to consider legality when considering whether a housing service was lost. but expressed concern with limiting the examiner's ability to determine when determining the value of the lost service. And I can't speak for whether the rest of that would be the same, but that's what I understand everyone else agreed with as well.
Okay, are there any other proposed changes or amendments to the minutes?
I move that we approve the minutes as amended.
Second.
May we have a roll call vote, please, with the amended minutes?
Commissioner Ayers,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Chair Copeland.
Aye, and the motion passes. Next up is public comment. Do we have any speakers from the public at this time, Mr. Secretary?
We have an Alex Safarian in the waiting room. Not sure who that is. I'll admit him now.
Should I read the disclaimer if we have a speaker? The Rent Stabilization Commission values your comments. However, pursuant to the Brown Act, the Rent Stabilization Commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. This public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within the jurisdiction of the Rent Stabilization Commission. Additional public comment periods will be offered later on in the meeting. You would like them to begin to speak now?
Mr. Safarian, can you hear us?
Good morning. I just got joined in. I didn't hear anything before you asking me if I could hear you.
Okay, this is a public comment period. I will read you that disclaimer again. Are you here as a witness for the appeal, or you're here to make a public comment?
I'm here. I'm the attorney for the property, so I'm
Oh,
here to
okay.
issues with the appeal.
Okay, Mr. Secretary, then we can put him on mute and bring him back for the appeal. Is that
Yes.
correct? Thank you. All right, thank you, sir. You can mute yourself and we'll bring you back in.
Thank you.
Thank you. There are no other speakers from the public at this time, Mr. Secretary?
No other speakers.
Okay. The next item up is the manager's report from our Rent Stabilization and Housing Division Manager, Mr. Holub, whenever you're ready for the report.
Thank you, Chair, and good evening. Good evening, Commissioners. Jonathan Hollow, Rent Stabilization and Housing Manager. First, for the look-ahead schedule, we have one appeal tonight, and staff from BetZedek will be giving a presentation on the eviction process. At our next meeting won't be until December 9th. We'll have 2 appeals then, and staff will be coming back with the regulations based on the discussion that we had at the last meeting about valuation guidelines. And given the fact that that is looking like only one of the last meeting we'll have this year, I intend on bringing other items related to regulation amendments and possible RSO amendments so that we can get that all done before the year's out. And on that note, the 23rd, we just learned that we will not have a quorum for the commission, so that the appeals scheduled for that day will be pushed off to the new year. Once again, as I've said at many meetings, any tenant in arrears or who is having trouble paying their rent, or a landlord who has a tenant in arrears due to COVID-related financial hardship should visit the housingiskey.com website. Not only are there funds available, but this is a form of eviction protection. And I'm sure that our guests from BetZedek will talk about that more later in the evening. Also, since they are here, I've asked Rachel Levy to, who's an attorney with BetZedek, to talk about what they're seeing in terms of the number of cases coming in right now. I know that's something that's of interest to the commission, and I thought since they're here tonight, they might as well address that. And following months, I'll talk about that as well as we get some numbers in. Thank you. Rachel, please.
Good evening, everyone.
So for the West Hollywood Eviction Prevention and Defense Program, so far in October, we've had 17 cases. This is a considerable increase from the past few months. We compared it to August and September and the numbers that we saw for those months, and it's actually triple the amount of cases that we had in August. So that's a considerable increase for us. Most of the tenants contacting us in October contacted us because they received notices to terminate their tenancy. A lot of 3-day notices to pay rent or quit, which the COVID protections, which we'll talk about tonight, landlords can again serve 3-day notices to pay rent or quit. So a lot of the cases that we saw were tenants who had received those. Most of those tenants had already applied and knew to apply for rental assistance through Housing is Key. And as Jonathan said, that's a protection from the landlord going forward with an eviction lawsuit. The ones who had not yet applied, we advised to apply if they were in fact eligible for that rental assistance. Other notices we've seen are 3-day notices to cure or quit, or notices just to quit. And we've seen multiple notices that we believe to be somewhat trivial, which perhaps wouldn't have been given in the past. And to us, that's a bit concerning because it seems like perhaps, a deliberate effort to maybe circumvent the protections that are currently in place. So that's what we're seeing. Certainly an uptick in the number of tenants that are contacting us with 3-day notices.
Great. Thank you so much, Rachel.
You're welcome.
And if commissioners have any questions for me, I'm available. I see.
Commissioner
Marshall? Yes, can you, Jonathan?
Hi.
There's a possibility that my vacation, which included the 23rd of December, it may be canceled. Would you like me to report back to you so we can go ahead with that meeting, or will there still be not a quorum?
My recommendation would be to check in with Roger tomorrow. I forget what the who else wasn't going to be able to make it. I can't remember if it was 4 or 5.
The chair and
Well, we polled the commission again after the last meeting, so there were more, and I think it best if you check in with Roger, and then we can report back on the. We'll let you know, but we'll report back publicly on the 9th as to whether we can go forward on the 23rd.
All right, thank you very much.
Thank you.
Thank you, Mr. Hollow. Next up, do we have any, I'm sorry, go ahead, Commissioner Kerpes, I'm sorry.
Thank you. I just had a question for Ms. Levy. Thank you for the information, by the way, on the evictions. By any chance, so on those notices of 3-day to quit, or the initial notice that the landlord gives to start the eviction process, have you noticed whether the attorney, or the landlords have been following the process of, I believe they're required to give notification at that point to for the tenant to have 15 days to contact or apply for?
Yeah.
Following that or not?
So under the latest version of the state protections, AB 832, there is a blurb that's required to be in 3-day notices about applying for rental assistance and how to do so. Some notices have it, some don't have it.
Thank you.
You're welcome.
Commissioner Topchin, please.
Thank you. I have a clarification question for Ms. Levy. You mentioned 17 cases. I probably missed that part. 17 eviction cases since September until now.
17 people have, we ran our numbers right before this meeting after I spoke to Jonathan. 17 people have contacted us in October for housing related issues under the West Hollywood Prevention Eviction Project. Yeah.
All right, so I probably misunderstood. I know that the representative for Bethesda will speak about the services they provide to people who have eviction notices or cases pending. My question would be probably to you or the manager. I know that the department doesn't review the notices. The department doesn't issue any letters. So is it only the referral that the tenant will receive if the tenant comes to the department or contacts the department with the eviction? So what type of service that the department will provide to a tenant who received an eviction notice, specifically to pay or quit or perform or quit? That's one question. The second question would, I'd rather answer the second question after your response.
You're asking me about what we do if we receive one at the division level, Commissioner?
Right. What
Right.
type of assistance or service would the tenant receive at
Right.
that?
What we're going to start
at the
doing, we
department?
haven't gotten many. We've only gotten a few this year, but what we're going to do going forward is reach out if we have contact information so that just in case the tenant doesn't know that they can get legal services from Betzedek.
Okay. With the, let's say the coordinator with the department, provide any information, at least some information on what to expect.
Absolutely.
So-
If we're in contact with them, we're going to give them
Some
any
information.
information that we think that they would need. Obviously, the most important one being to contact counsel, and if they can't get their own counsel, to contact Betzedek as quickly as possible due to the summary nature of the proceedings.
Would that be a good idea maybe for a coordinator to check if the unit is properly registered and if there are any pending code violations in the unit that could basically be an affirmative defense in court, if there are unpaid registration fees or pending code enforcement issues. So maybe the tenant can be provided that type of information. So I want to see what we can do at the department to provide as a tool, as a defense before the tenant goes to the Betzedek.
Well, the problem is that we can't provide defense services. So, but if counsel seeks that information, it's certainly available.
Okay. All right. Thank you.
Any other
That's all, Madam
questions?
Chair.
Any other commissioner questions this time? All right, thank you. Next up, we have commissioner comments. There are any commissioners that would like to provide comments or disclosures at this time? Nothing at this time. Commissioner Maggio, are you with us? There we are. Okay. No comments at this time or disclosures. Okay. Well, the next, before we go into the appeals portion, do we have any public comments at this time, Mr. Secretary?
None at this time.
Okay, thank you. All right, next up is our appeal. And we have an appeal before the commission this evening, D-4585. Do we have a representative for the tenant and for the landlord?
We do. I'll admit them now.
Thank you.
Chair, I don't mean to interrupt, but just want to jump in as just for purposes of consistency and for the record, as much as I would enjoy Ms. Levy to stay, I would just ask the secretary just to make sure that only people in the room are those that are either the party, commissioner, or staff, and to just place Ms. Levy in the wait room while we do this appeal.
Thank you. Okay. Do we have both parties in yet?
Yes, we have both parties with us. I'm not sure if Mr. Doty can hear us.
Yes, I can hear you.
Okay, great. Thank you. These are the instructions for the appeal. First, we'll hear a staff report from our commission's legal counsel. And then in this case, both parties filed an appeal. So the party who filed the first appeal will go first. In this case, that will be the landlord. You'll each have a total of 5 minutes to discuss your appeal. You'll have the option of dividing your 5 minutes into 2 segments. So if you would like to do 3 minutes for your testimony and then 2 minutes for a rebuttal, or 4 minutes and 1 minute, or if you'd like to do all of your 5 minutes at one time, you're able to do that. When it's time for you to speak, you'll unmute yourself and then state your name and city of residence for the record, and then state how you would like to divide your time, if at all, and then proceed with your comments. Since your speaking time is limited, it's very important to keep the following things in mind. Stay on topic. The only information you share should be about the appeal topic. New evidence cannot be considered by the commission. You can only discuss issues that were raised at the hearing or evidence that was submitted to the hearing examiner. So at this time, Mr. Natalizio, may we have the staff report, please?
Thank you, Chair. Good evening, Chair and Vice Chair and Commissioners. John Natalizio. I am the legal counsel to the Rent Stabilization Commission for the city. As the Chair stated, both parties filed an appeal in this case. The landlord is Emma Rubin Trust, and the tenant is Nancy Sweeney. And these appeals were filed in response to the hearing examiner's decision that granted in part and denied in part a rent reduction application relating to various housing services and minimum maintenance standards. The tenant resides at 1226 North Larrabee Street, Unit 3. Relevant to this appeal, tenant's application sought a rent decrease on the following unique unit issues. They're relating to her window screens, windows, the rear bathroom ceiling leak, shower grout and sealer, a toilet bolt cap, and relevant to this appeal, the tenant's application sought a rent decrease on the following common area issues. The laundry room door, laundry room window, rear door, parking spaces, stairway handrails, and front door issues. A decision was issued on July 13th, 2021, which in relevant part approved the following requests for rent decreases. There was a $14 rent decrease for her specific unit's window screens, a $30 rent decrease for the building's rear door, a $3 rent decrease for the building's laundry room screens, and a $30 rent decrease for the building's front door. Therefore, relevant to this appeal, the hearing examiner awarded a $14 rent reduction to the tenants for issues unique to her unit, and a $63 rent reduction to all qualifying tenants for common area issues. Thus, relevant to this appeal, tenant was awarded a $77 rent reduction. On July 23rd, 2021, landlord filed its appeal of the decision. The appeal claims that the decision is an error. Specifically, landlord is only challenging hearing examiner's conclusion of law number 3, which grants a $30 rent reduction to all qualifying tenants for the incomplete closure of the front door. And landlord's appeal argues that the front door closes completely. On July 25th, 2021, tenant filed her appeal of the decision. The appeal claims that the decision is not reasonably supported by the findings made or the evidence in the record, and that it's contrary to the law. Tenant's appeal includes various argument and requests for relief relating to a number of issues. Regulation 60035 provides that matters not raised in the appeal are deemed final and therefore cannot be considered by the commission. Staff has reviewed the appeal record and recommends affirming in part and reversing in part the hearing examiner's decision. Staff believes that there's substantial evidence supporting the hearing examiner's decision relating to the unit's window screens, windows, rear bathroom ceiling and curtain rod, bathroom grout, the bathroom's missing plastic toilet cap, the tenant's missing front door key, the building removal of an automatic door closure on the laundry room, the building's broken laundry room window, the building's removal and replacement of the rear door, the elimination of the painted parking stall numbers, and the building's front door problems. Staff believes the decision is not supported by substantial evidence relating to the elimination of the building's entrance, stairway handrails. The hearing examiner evaluated this only from a code compliance perspective. While the hearing examiner was correct that there's no code requirement that there be 2 handrails, the hearing examiner did not analyze this elimination of a handrail from the perspective of a housing service. To that end, staff believes there lacks substantial evidence supporting the hearing examiner's decision. The guidelines provide $14 for gates and fences involving security issues, which staff believes is equivalent to a handrail. Therefore, the staff recommends the commission award a rent area reduction of $14 for all qualifying tenants. Therefore, based upon the above, staff recommends adopting resolution RSC 21-602. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, the decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you. Are there any questions for legal counsel at this time from commissioners? Okay, we can go ahead and begin the appeal. Who will be speaking for the landlord in this case?
We have both. Sorry, Mr. Safarian, can you hear me?
Yes. Can everyone hear me?
Yes.
Yes, my name is Alex Safari, and I'm an attorney for the landlord.
Could you, Mr. Secretary, are we having two speakers for the landlord or just one? Pardon?
Yeah. We also have Doug Doty here.
Okay, so will they be dividing their time or just one speaker?
Just one speaker.
Mr. Doty is available if the commission has questions. He is the current property manager.
Okay, so you will be speaking for the property owner then. Could you state your name again, please, and your city of residence for the record?
My name is Alex Safarian, and I'm a resident of the city of Burbank.
Okay, and how would you like to divide your 5 minutes for testimony and rebuttal, or just use the entire 5 minutes at once?
For testimony and rebuttal, please.
Okay, and how would you like to divide that?
I would like to save 2 minutes for rebuttal.
Okay, Mr. Secretary, we have that.
Yes.
Okay, you may begin. Okay, just to start off, I agree with the hearing examiner's findings for everything except for the front door issues. One of the issues that was not discussed in the staff report is the doorbells and buzzers, which was coupled with the front door issues. It was my understanding that these were all front door issues, which they said coupled together denotes an elimination of a housing service. So we disagree with that because the issues have since been resolved. So those issues should not have been determined together. They should be determined separately. I know that doorbells and buzzers are not before the commission at this time. However, in the examiner's original report, it said that coupled with the exterior doors, it denotes the elimination of a housing service. So we would like to revisit that because it has been since then, all of those issues have been resolved. As for the other issues, basically everything has been resolved. So I'm only going to address the other issue that was appealed by the tenant. As for the handrail, we agree with the hearing examiner. Yes.
I'm sorry. The only issue that was on your appeal was the door. So if I'm not mistaken, that's what your testimony should be about. Is that correct, Mr. Natalizio?
If Mr. Safarian wants to address the tenant's appeal, I think that that's fine.
Okay.
As long as it's limited to what's in his appeal, his being the landlord or the tenants.
Thank you. Okay, go ahead, sir.
I agree. The only reason it was brought up is because the hearing examiner did couple the issues of the front door along with some of the other issues. But as for the tenant's issue with the handrail, it is not defined. It is not a housing service. According to the definition in the RSO, a handrail is cosmetic, and we agree with the examiner for the handrail and their determination. And we don't think that that's something that should be considered based on what the staff report says, because this is not the removal. There is still a handrail and it's still functional, and it's purely a cosmetic issue leading up to the building. It's not a gate or any type of security feature. And that'll be all for me at this time.
Okay, Mr. Secretary, how many minutes does he have left?
2 minutes and 50 seconds.
Okay. Okay, and we will hear from the tenant. If you could, again, please state your name and your city of residence and how you would like to divide your 5 minutes, if at all.
Hi, I'm Nancy Sweeney and I live in West Hollywood. I'll do 3 minutes. If I go slightly over, I'll just use whatever remaining time is for the rebuttal.
Thank you. Okay, you may begin.
Thank you, and thanks for meeting with you. The primary reason for my appeal is to have the effective date of the rent decrease be retroactive to the date that I submitted for a rent reduction, which was January 5th, 2020. The owner has several apartment buildings in West Hollywood, and they are aware that my unit has not been painted in over 20 years. And they're aware that they are required to paint it, and they just don't want to. For the last 5 years, tenant maintenance requests have been ignored as a business practice. And our only recourse as tenants is to engage the city in a several months long process until a judgment is served before the work is performed. I pay my rent on time, and I believe they should make timely repairs. And we as tenants have been awarded rent reductions in the past, and for many of these same issues, and the city granted the rent reduction requests, and they made sure the award date was retroactive to when we submitted our request. And I'm asking that you be willing to do the same in this case. Otherwise, there'll be no reason for them to change. This will just be a matter of course. And again, it's not just for me or our building, it's several buildings in West Hollywood. Doorbells and remote entry, they're not working. It's something that we had for decades, and it was, they broke it and they didn't replace it. Windows. The determination was an error because the windows need repair. After 20 years, the window wheels have worn down to nothing. Without wheels, these sliding windows do not work. And it's as if renting a bicycle and the rubber tires worn down and fell off. And it's as if the hearing examiner was like, well, you can still ride on the rims. And I don't feel that's comparable. The rear door, the hearing examiner erred because he didn't include in his determination that the screen door is not of comparable quality. We previously had a steel security door, and they replaced it with a cheap screen door. And the screen door is not comparable. It doesn't provide protection. Anyone could just kick that in. The laundry door, he erred because it's not providing the same service. The previous door had a device that prevented it from swinging all the way open right into parking lanes where there are cars. And this new door doesn't have a device that makes sure that it doesn't just like fly all the way open. So that was a lot, in my opinion, that's a loss of service. For the shower grout, I believe the hearing examiner erred because the shower repairs were not of comparable quality. The new maintenance company inspected it and they were like, yes, this was done all wrong. The grout falls off. The sealer is cracked and the grout was installed wrong. And I feel like the repairs weren't done properly. I informed them of that immediately after the guy left, and they're just kind of like, deal with it. So I feel like that's not of comparable quality. And so I'll leave it at that. Thank you. And I'll save my time for rebuttal.
Okay, and how much time is left for that? I'm sorry.
1 minute and 56 seconds.
Okay. Commissioner Karpes, you had a question?
Yes, thank you, Ms. Sweeney, for your testimony. I do have a question. You may have seen in the staff report that under item 9 is what it's listed as, but it's the decision relating to the building's rear door, which you just spoke of, about the originally being a heavier and secure self-closing door, but was replaced with a new metal screen door that is less secure and does not fit the door jamb. You prevailed on that issue in receiving a $30 rent deduction. What is it exactly that you're asking for?
It felt like the rent reduction was for the door not closing, but I'd also like to have them change the door to a security door.
Thank you.
Thank you.
Commissioner Topchin.
Thank you, Madam Acting Chair. I have a question for Ms. Sweeney. Regarding the parking spaces, the designated numbers on the wall, you mentioned that it is vital, but why it is so important, why it was so vital? Did you have trouble parking on your spots or designated spaces? Was there any dispute whether these two spaces they assigned to you? Can you explain a little bit more, because there was nothing provided in the hearing?
Thank you. Yes, thank you for that question. The previous management company actually threatened to tow my own cars out of my spaces. And I said to them, I was like, these are my spaces. They're on my lease. And but they didn't know that because they had painted over the numbers. And
on the lease, it identifies number, I believe, number 3.
well, yes, that when I moved in, just like my unit was identified by the number on the door, the numbers on the spaces also had the same number. And they painted over all of our numbers and have threatened to, again, they've told me that I don't have those spaces. They were like, we're in charge. If you don't, they took a photograph of my car and they emailed it to everyone in the building and they said, we're going to tow you. And
But there was a prior management, nothing from this property ownership.
Correct. Nothing from this property ownership, and they've been doing it for a few months.
Okay, and I wanted to understand the why it was very important. You explained it to me. Thank you very much for that. But I also want to acknowledge that you have not suffered a reduction of your parking privileges. They were not removed.
So far, they have not told me or done anything like that.
Okay.
They've the previous management company suggested that they were entitled to do that, but it never happened.
I see. I appreciate that. Thank you very much.
Thank you.
Nothing further.
Thank you. Any questions at this time, or shall we let them begin the rebuttal? No further questions? Okay. Can bring the representative of the landlord back for a rebuttal, please. And he has how much time, Mr. Secretary?
2 minutes and 50 seconds.
Thank you.
This is Alex Safarian for the landlord. I just wanted to point out that Ms. Sweeney's arguments did not controvert any of the findings. If she's bringing in new evidence and trying to have the evidence reconsidered, however, that's not the standard. The decision must still be upheld, even if there's contrary evidence. I just want to remind the commission that we cannot consider any of those new arguments. That'll be all. Thank you.
Thank you. I'm sorry, Commissioner Kirby, you have a question?
Yes, I did have a question for Mrs. Safarian from actually your first few minutes of testimony. When you referred to the handrail, you mentioned that there is another handrail in its place. You made some reference, and I didn't see that in the record or in the picture.
No, there were, I believe there were, in the examiner's report, I believe they mentioned that there was 2 handrails, and when they made a replacement, they replaced and they left one handrail on one side for anyone to be able to use if they needed the use of the handrail. But to have 2 handrails, it's purely cosmetic for the entrance of the building.
So it looks like the pictures I'm looking at, I can only see one side at a time, and I don't know when they were taken. Are you saying that presently, at the time of the hearing, there was one side would have had that, looks like cast iron railing removed, and the other one stayed?
I would defer to Mr. Doty. He's the current property manager. He would know better the current status. I only have what's before me in the examiner's report.
I'm unsure as to the status of the handrails.
All right, thank you.
Any other questions for the, yes, Commissioner Topchin?
Thank you. Just since Commissioner Kerpis touched this, the handrails, Mrs. Safarian, you keep referencing it's for a cosmetic reason. When I'm looking at this picture, I see it's a metal solidly installed handrail, at least one of the picture that is provided. So why you're saying it's for cosmetic purposes? What do you mean by that?
Well, I'm saying the fact that there are two handrails, just so they would be, parallel one on each side that you would find in the entrance to the building. To have two of them is for cosmetic reasons, for the appearance. However, if just having one handrail still serves the purpose, if anyone needed to use the handrail to be able to go up and down the property. But in addition, my argument was that this is not a housing service. And I think the examiner was correct when it said that the handrails are not a housing service and could not be reduced on the basis of a reduction of housing services.
Okay, thank you.
Any other, Commissioner Maggio?
Yes, to the gentleman, I would think that the railing would not be cosmetic, that the railing is there for a purpose because someone could be disabled on the right side or the left side. So they may need that railing on that particular side to assist them. That's just the comment I want to make. Thank you.
Thank you.
And
We have any further questions at this time?
may I address the commissioner's comment?
Go ahead.
Commissioner, I don't believe there's a requirement, ADA requirement or any city requirement that would require two. If there is, then we would definitely consider it. However, it's my understanding that there is no requirement, then having two would be more cosmetic just to have it, to have them on both sides. But that's...
Well, you keep on referring to it as cosmetic, and I'm saying that it probably is not cosmetic for a very specific reason.
The reason why I say it's cosmetic is because the railing is there. The railing was not removed. However, when you have two of them in front of the building, it's usually done for the appearance, so it would appear the same on both sides.
Okay. Are there any further commissioner questions this time? Okay. If there are none, then we will let Ms. Sweeney, if you would like to resume for your rebuttal at this time. Mr. Secretary, how much time does she have left?
1 minute and 56 seconds.
Thank you. Can you unmute and begin speaking? Thank you.
I guess, I just want to thank everyone. I'm sorry that we all have to engage the city for something. This originally, I've lived here for 21 years in this building. I've never had an issue. And it's just these issues just happened over the past 5 years. And so the fact that I was forced to engage the city because what we're required to do is submit tickets in a portal, and these tickets would just be deleted. And these were just for some basic things. I've had to engage code compliance officers. They've come, they've required the owners to perform maintenance. I had to have a code compliance officer come back and redo work. Some of these issues that I'm talking about are issues that were from our last rent reduction hearing. And because they didn't use things of comparable quality, we have to do another hearing. And anyways, it's just been a whole thing. So I appreciate everyone's time, and I hope that whatever you determine will hopefully be an incentive for them to just do their part and in a timely way. Thank you.
Thank you. Do we have any commissioner questions at this time for the tenant? If there are none, then you may both mute yourselves, and we will move on to commissioner deliberation. Do we have any questions for legal counsel at this time, or are you ready to start comments? Commissioner Kerpes?
Yeah, I do have a couple of questions. First of all, Mr. Natalizano, the tenant mentioned backdating the date of the rent reduction, and made even a reference to in the past it's been done. I know that you've been here for this last year, but beyond that, you may not have any personal recollection, but are you aware of how that could have happened if it did, or under the current code and how it's written, that there's no option for that? Is that right?
Yeah, I guess you're correct that I have no idea how in the past, if that did happen, how that would have happened. The regulation that governs this is 60038 and subsection B of that. And what that says is that for a downward adjustment, it is from the date of the decision of the hearing examiner. So if there was something that happened in the past where it was backdated to the date of the application, I'm not aware of it, or the circumstances involved in that.
Is it the date of the hearing examiner's decision unless it's appealed? And then if it's appealed, what is the date?
I don't think that the appeal would change the date.
Okay.
The regulation just puts it at the date of the actual decision.
So if we decide tonight to uphold the hearing examiner's decision, for example, that would trigger a rent reduction dating back to the date the hearing examiner released the decision.
Correct.
Okay. And then I think the only other question I have for you is in your staff reports, you mentioned that under the railing issue, you, I believe, made the reference that though the hearing examiner did not analyze the elimination of a handrail from the perspective of a housing service. When I first read that, I read it as to mean the hearing examiner may have overlooked it, opted not, like there was no discussion of it. But as I read the hearing examiner's decision, I get a different impression in that maybe he opted not to look at it further than something, what'd they say, something visual or something. So I guess my question is, what do you meaning? What is your meaning? What are you intending to mean in the staff report when you say it was not analyzed for that purpose?
So my understanding of when I read the hearing examiner's decision is that it was analyzed purely from the standpoint of whether or not it was being maintained in accordance with all applicable codes, whether it's the RSO or some state, health and safety code or something like that. My understanding when I was reading the hearing examiner's decision was that it was not analyzed under the guise of were those handrails a housing service, and if they were their elimination resulting in a substantial reduction in the housing service. And so there's, in my mind, there were two tracks, right? There's like this maintenance requirement / code requirement, and then also a housing service analysis. In my reading of it, I did not read it to include that housing service analysis. And I thought because that was missed, had the hearing examiner actually considered it as a housing service, he should have found, in staff's opinion, that there ultimately was a substantial reduction in the housing service. It's particularly if you're looking at what the definition of a housing service is for this applicant. Does that answer your question?
It does, I believe. So I guess my question would be on page 12, it's page 63 of our packet, page 12 of the hearing examiner's decision, underneath the stairway handrails section, that first paragraph, halfway through, it looks like the last two sentences, here tenants ascending to or descending from the front door have a railing on each stairway to ensure their stability. With the removal of 2 of the 4 handrails, an aesthetic issue has again been raised. but not an issue compelling decreased rent due to the elimination of a housing service. So in my mind, it does, and maybe I'm wrong, but how I read this is it does explicitly state that the elimination of a housing service was determined, weighed in his decision. And it sounds like the conversation that occurred at the hearing was all about I do understand the emphasis on the code and the maintenance, but then for the issue on why can I not think of this word? Aesthetics. That's what I'm thinking of. On the issue of aesthetics, I mean, aesthetics would never be a code compliance safety issue. Aesthetics would fall closer to a housing service. So I guess I'm just trying to, and maybe you don't have another answer. You did answer my question. So that's just something I will be kind of rolling around in my head, I guess, as we move forward.
Sure. And again, the commission's free to disagree with staff's opinion or staff's recommendation if you feel that the hearing examiner did address it and ultimately there is substantial evidence to support that. The commission's free to do that. Staff's reading of this is that it wasn't, but you were not bound to that.
Thank you.
Any other commissioner questions for legal counsel this time? I do have one then, Mr. Natalizio. The tenant did make some requests in addition to the backdating of the date of the rent reduction. Also made some comments about specifics as far as replacing doors with certain kinds of doors and so forth, which is of course beyond the purview of this commission to order those things. Is that correct?
Correct. If that was the point of a rent reduction is not for the city to be able to order a landlord how to manage the property in the sense of you need to replace this door with this other door. The rent reduction is there to compensate the tenant for the fact that there has been some sort of reduction in the housing service or some sort of failure to maintain, and it's not being reflected accurately in their rent. If the landlord believes they've complied with the determination, they could always file a compliance determination to that effect. But the commission doesn't have the power to order a different door be put in.
Thank you. I just wanted to clarify that for the Commissioner Maggio, please. Did you have your hand raised?
Yes, I did. And to
Okay.
legal counsel, in regard to the door again, because the door was initially specifically a security door and then it is not replaced with a security door, to me would be quite a difference.
So
if it's aluminum screen door versus a real steel door, to me, that's a difference.
So I guess the confusing thing is there's 3 doors in this appeal. There's the front door issue, the rear door, and the laundry room door. Is there one specifically?
Okay, that's the clarification. Thank you.
Thank you. Anything else for legal counsel at this time? Commissioner Topchin, please.
Thank you. I just wanted to ask Mr. Natalizio, maybe the tenant's confusion is with the when the RSO states that the replacement of the service must be comparable quality, and maybe maybe you can provide some sort of a kind of a good explanation, as you can of course do, for the tenant, for the parties to understand the nature, what does it mean, the comparable quality? So that may answer the question that the tenant may have. Thank you.
I guess to the extent that I understand, I guess what the tenant is talking about with this comparable quality, I mean, that's a phrase that's used in the RSO, but it's used for only specific things, like, for example, window coverings and carpets or vinyl flooring, new wallpaper. To the extent that we're talking about doors or something else. That kind of depends on the specific fact scenario, and also ultimately depends on if there's an actual housing service that's being reduced. So I think it's a little bit more complicated than just everything needs to be replaced with comparable quality. But traditionally, if we're looking at comparable quality, that's in 17.56.010, the maintenance standards.
Okay, thank you.
Any other questions for legal counsel this time? Okay, thank you. So we can go into commission deliberations then. Who would like to begin? Comments, volunteers?
I can start.
Okay, Commissioner Topchin.
It's going to be very short. I read this over and over again because there are so many items, so many issues that we wanted to obviously review and make sure that we didn't miss anything, and that we would apply the RSO in full force. And I'm going to tell you, I'm in full agreement with the staff's recommendation to affirm in part, and to reverse in part. And there's no question to me that the staff's recommendation is supported by everything that is submitted as evidence. And I agree with the part regarding the handrails. So obviously they are not for aesthetic purposes. They've been there for to provide safety, to provide security when people are using the stairs, they're going up and down. And the pictures they suggest are definitely not aesthetic. They're not for aesthetic purposes. Even if there were two, these handrails they are housing services. Why they're housing services? Because they've been there since the tenant moved in. So the bottom line is, and I see that that happens all the time when tenants or landlords, most of the landlords, when they file their appeals. So the bottom line, if this was provided at the time of renting this unit and the tenant had it as part of the tenancy agreement, when the tenant paid the rent and had this handrails there, later it was removed, that is a reduction in housing services, which will require a reduction in rent. So in regards to whether it's aesthetic or not, for some of the aesthetic items, we would pursue a rent decrease. For example, if it was a flower pot that was provided as for beautification purposes, definitely, or if it was a tree in front of or some plants in front of the tenant's unit that were removed. So those are definitely for aesthetic purposes, but we would pursue a rent decrease. The city would pursue a rent decrease, and we would uphold that decision because that was a service. Anything and everything is a service that is available to the tenant for which the tenant pays rent. So the argument that this is was for aesthetic purposes and one could be removed and the one can be used, I don't find that credible argument. So I believe the staff's recommendation to reverse in part is fully supported by the evidence. And thank you for clarifying. I was going to make the same comments, Commissioner Kerpis. This is not a code-related matter, but it's a housing service. So therefore, a rent reduction is required. And that's it. Thank you.
Okay. Who would like Commissioner Maggio?
Yes, I agree with the decision in regard to the issues of the windows, window screens, rear bathroom ceiling leak, shower grout sealers, toilet bowl cap, front door key, the laundry room door, laundry room window, the building rear door, and the parking spaces in the building in front. Also, I support the hearing examiner's decision to reverse in relationship to the stairwell hand railing. I believe also that it's not there for aesthetic purposes. It's there for safety reasons. And again, as I said earlier and would reiterate now, someone who may be disabled may need the right side or the left side. Those have to be considered strongly in regard to disabilities. So therefore, I'm going to support the hearing examiner's decision in its entirety. Thank you.
Sorry, I just want to clarify, you wanted to support staff's recommendation to reverse the hearing examiner's decision on the railing. Is that correct?
Yes.
Okay. Thank you. Commissioner Ayers?
I'll be brief. I support and agree with the comments made by Commissioners Topchain and Maggio. I'm in agreement with what the staff is proposing as far as affirming much of the hearing examiner's decision, with the exception of the issue with the stairwell handrails, and that part should be reversed. Thank you.
Thank you. Commissioner Kerpes, yes.
So I will save you all an argument, or save you all from my argument that why I might disagree with you on whether the removal was a removal of a service in this case. But I would hope that any tenants or anyone making the argument in the future to please actually make the argument to the hearing examiner how the removal of the item is actually a reduction in service, because that is the question. And that does not, to me, appear to be a discussion that occurred with the tenant and the hearing examiner. I agree that there are several reasons why it could be a housing service, and I will even agree to vote for in favor with it seems where the majority is going based upon that being a housing service and agreeing with staff's recommendation. I do, though, separately still have a concern about the dollar amount and what we're equating it to, because I do not see this as a gate / fence / security or a security gate or security fence. So I would hope that we would evaluate that and not place it at the same value as like an actual security gate or an actual fence that's going to keep people, away from each other, or animals away from people, whatever it may be. The other issues, I agree with the hearing examiner and on the staff on. I would say that I think it's already been said, but I just want to remind the tenant that this isn't about us replacing the items the way that he or she would like them to be replaced. It's about focusing on whatever services they received a reduction in and being compensated for that. So in terms of that $30 or the back gate, and I think two other issues that she mentioned, I think that she is being compensated, and all the tenants are being compensated appropriately for the lack of, or for the reduction in housing services for those items. So I will leave it there. Let someone else speak.
Thank you. Commissioner Montemayor.
Thank you. In short, I agree with my fellow commissioners and I agree with staff's recommendations. I am intrigued by Commissioner Kerpes' comment, and I would love to maybe dig into that a little bit more. What would you suggest would be a value for the handrails?
Very difficult because I don't see much on our guidelines list to really.
Yeah. And yeah. I agree with you. I struggle with this as well. So I'm just curious if other commissioners have any thoughts on this.
There any thoughts, other commissioners, on evaluation? Commissioner Topchin?
I just want to say this. Obviously, the guidelines will not provide each and every possible service for the purposes to make a decision. I've always been supportive of the commission being able to revise the amounts of rent reduction that were enforced by the examiners. But here it's a different matter because why? Because the staff looked into this. They used whatever factors they had, including probably the rent level and all other factors, and they've determined that the reasonable amount is $14. So what is the purpose of the handrails? To provide safety. And what is the closest on the guidelines? That's how I think the logics were behind this $14 decision. What's the closest to the safety? It's safety. It's with security gates or fences, security safety fences, or whatever we have on the guidelines. So obviously, that would have been the logics to use in order to come up with the reasonable amount, because you don't want to just pull the number from from the blue air. So what I believe, if we have to revise this, I think this service is so important, then I would actually go above $14 because as Commissioner Maggio correctly pointed out, that a person may have a disability on the right side or on the left side. So both handrails are equally important to have at place. So therefore, if we're gonna enforce a rent reduction, I would say that rent reduction should be even higher because the value, because the importance of this service. So, however, for this case, I wouldn't touch it. I would just go based on what the department reviewed and provided, and I think this is a reasonable amount based on the factors that the department used. That's my argument and my comment.
Commissioner Kerpes and then Commissioner Maggio.
Yeah, I understand that, and I think staff we have a reasonable staff that will make reasonable decisions and makes excellent recommendations to us. Although the fact that it comes from staff and not from the hearing examiner actually leads me to be more likely to change it, and that has nothing to do with me disrespecting staff or anything like that. But it's outside of the normal process by doing that. But setting that aside, the conversation here, we keep on talking about the safety. So we're not supposed to reweigh the evidence. The safety issue was not an issue. The hearing examiner reviewed the safety issue. There's no code violation. It wasn't a safety issue. But I understand it if the majority believes that it was a service, even though I don't feel that the tenant made that argument. So we shouldn't put too much weight on this and keep talking about it being a security issue or safety issue. It doesn't have to be a safety issue to be a loss of service. So I just don't see it being a safety issue.
Okay, Commissioner Maggio.
I just like to add that I think that the $14 decrease is fair and equitable. Although I think we might want to look at hand railings now in the future to maybe memorialize a more specific number, considering it higher. But I think at this point, we have to keep it at $14.
Okay. Any other comment on, is anyone like to make a motion yet on this? I'm sorry.
I'm sorry. Can I just jump in real quick?
Absolutely, sure.
Before you guys did a vote, I wanted to address Commissioner Kerpes' question to me just before, not about the hand railings, but about the effective date of the appeal. I've had a time to actually read the regulation. I just want to clarify that this is what the regulation says. It says the effective date of the decision is the next rental due date, provided that such date is at least 5 days after the mailing of the notice of the decision. So that would be the effective date, not the date of the decision, but the effective date of the decision is the next rental due date, provided that such date is at least 5 days after the mailing of the notice of decision. So I just wanted to correct myself and make sure that wrong information wasn't out there.
Thank you. Appreciate that. So at this time, does anyone like to make a motion? Commissioner Maggio, you had your hand up first.
Yes, I would like to make a motion to adopt Resolution RSC 21-602, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and reversing in part the hearing examiner's decision as to application number D-4585.
I'd like
Do
to
we have a-
second that motion.
All right. We have a motion and a second. Mr. Secretary, may we have a roll call vote, please?
Commissioner Harris,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Chair Copeland.
Aye. And the motion passes. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 or by email at rsh@weho.org. The parties will now be placed back in the waiting room. If you'd like to watch the rest of the meeting, you may find your options to do so at weho.org/WehoTV. And thank you very much for your participation.
Chair, may we have a 3-minute break?
Yes, we will take a 3-minute break beginning now. Thank you. think everyone is back. Okay. Before we begin with new business, do we have any members of the public that wish to speak, Mr. Secretary?
Not at this time.
Okay, so we move on to new and unfinished business, and we have Beth Zedek presentation on the eviction process. Manager Holub, do we have an introduction for this presentation?
Yeah, just very briefly, I'd like to introduce and thank Ala Chasnik, Hannah Kamal, and Rachel Levy, who you met earlier, for coming tonight to from Beth Zedek Legal Services to give the commission and the public a presentation on the evictions process. So I'll turn it over to them, and thank you very much again for coming.
Thank you.
Good evening. It's nice to see everyone. Hope you're all doing well. Thank you for having us here today. We're going to give a presentation on the eviction process and the COVID-19 protections. My name is Ala Chasnik. I'm the staff attorney and director of the West Hollywood Project. And presenting with me today are, as Jonathan said, Hannah Kamal. She is also the staff attorney of the Preventing and Ending Homelessness Project. And as you already met, Rachel Levy, who is the staff attorney for the West Hollywood Eviction, Prevention, and Defense Program. As you probably know, Beth Zedek Legal Services provides free expert legal services and representation to residents of LA County. We serve clients regardless of race, religion, ethnicity, immigrant status, or gender identity. The Preventing and Ending Homelessness Project provides eviction defense services in Los Angeles, Beverly Hills, Culver City, and our very own West Hollywood, with whom we've had a particularly long partnership over, I'd say, at least 22 years, where we provide free legal services to all constituents in the city of West Hollywood. Tonight, as I think Jonathan mentioned, we are going to present on the eviction process and the current COVID-19 eviction protections, which include state law as well as county protections. So without further ado, I'm going to pass the mic over to, I think it's Rachel who's going first, and she is going to talk about the eviction process.
Thank you, Ala, and good evening again, everyone. Yes, as Ala said, I'm going to talk about give you an overview of the eviction process. Here's a flow chart that's very helpful in understanding how an eviction case makes its way through the court. So I'll just explain what we see here. So most cases start with the landlord serving a notice to terminate a tenancy. That notice is served on the tenant. Some examples of notices are 3-day notices to pay or quit, 3-day notice to cure or quit. In some instances, a 60-day notice. So the tenant is served with the notice. If the tenant does not comply with what the notice says within the time allotted, the landlord can then go to court and begin an eviction lawsuit, which is known as an unlawful detainer. So under the RSO, as you all know, the notice must contain specific information about the grounds on which the landlord is seeking to terminate the tenancy, and it has to be one of the permissible grounds that are listed in the rent stabilization ordinance. So the next box down you'll see is the summons and complaint. And those are the two documents that begin an eviction lawsuit, an unlawful detainer case. Landlords or agents acting on behalf of the landlord must personally serve the tenant unless they get permission from the court to serve in an alternative way after trying to serve the tenant personally several times. And also, as you know, under the RSO, a landlord must serve a copy of the notice with the commission within 5 days of service on the tenant, as well as a copy of the summons or complaint within 5 days. So then the next box down you'll see is the answer. Once the tenant is served, they have 5 days to file a response with the court known as an answer. If there is no answer filed by the deadline, the landlord can get a default judgment against the tenant. That leads to the issuance of a writ of possession, which allows the sheriff to post a 5-day notice on the tenant's door. and ultimately lock out the tenant if the tenant remains in possession of the unit after those 5 days. If the tenant does answer, the case proceeds through the court process and can get resolved through settlement or through trial. The next slide just shows a summons. So as we just discussed, a tenant has 5 days to respond once they are served with the summons and complaint. And we just thought it was important to see a summons because they're actually very important right now as they relate to the state COVID protections, which Hannah will discuss later on. Okay, next slide. So next, we're going to transition into discussing the current state of the COVID-19 laws that protect tenants in West Hollywood. So on the left, you'll see there's state law that limits evictions for non-payment of rent. And Hannah will soon discuss how those protections changed on October 1st of this year. Beginning back in March of 2020, and I don't know if that seems like yesterday or a lifetime ago, but the West Hollywood City Council passed a series of ordinances that were aimed at protecting tenants from eviction. Then in September of 2020, the ordinance was amended to conform with a state law, AB 3088, which was the first California state law passed concerning eviction protections. That particular WeHo ordinance set forth 4 permissible grounds for eviction, which were actually established in a previous ordinance. So sorry if I'm being confusing, but previously there were only 4 permissible grounds that a landlord could evict in West Hollywood. Then as of July 1st of this year, West Hollywood tenants no longer have those separate 4 protections, but they are instead protected by the county emergency tenant protections. And those protections were recently extended through January 31st of 2022. And we'll talk about that after Hannah discusses the limitations on evictions for non-payment of rent. But those evictions are related to other types of evictions besides non-payment of rent.
Thank you, Rachel and Ala, and good evening, everyone. I'm glad to have the opportunity to speak to you all tonight. So first, we're going to just discuss a recap of what the state law protections were doing up until September 30th, 2021. Sorry, September 30th, 2021. So between the months of March 2020 and September 2021, until recently, there were certain protections in place. So a landlord had to serve a tenant with a 15-day, a landlord that wanted to evict for non-payment of rent had to serve a tenant with a 15-day notice to pay rent. And then they also needed to provide a blank declaration of COVID-19 related financial distress. And the idea is that the tenant, if they could not pay their rent because of COVID, that they would submit the declaration within the appropriate time period. And for certain months, for the months of March to August 2020, that was, if their landlord was asking for rent from those months, all the tenant had to do was submit a declaration. For the months from September 2020 to September 2021, the tenant had to not only submit a declaration, but also pay 25% of the rent for those months in question by the end of September 2021. So that's where things stood until pretty recently. Now, starting October 1st, 2021, landlords can serve a 3-day notice rather than the 15-day notice. And that's specifically for rent that came due from October 1st, 2021 to rent that's going to come due in March 2022. So it's true that now landlords can give 3-day notices again. However, if they are seeking rent that came in that earlier time period, the March 2020 to September 2021, they still need to do the 15-day notice, and they still need to provide the declaration. And additionally, with the 3-day notice that's starting on October 1st, there is specific language that needs to go into the notice. And just a quick note that these protections apply until the end of March of next year. So right now we're just talking about kind of a temporary period of time of 6 months where we do have 3-day notices again, but there are some additional protections. Okay, so even though there are 3-day notices, again, once more, there are some additional protections that state law provides. So first, we're going to talk about how rental assistance applications can be used to prevent tenants from getting evicted. There are a few different ways that rental assistance applications come into play. So Rachel talked about that the eviction process and how it starts with the notice, goes through the summons and complaint, and eventually can end up in a judgment. This step I'm about to talk about, this step can be used really at any point in the eviction until the tenant actually gets locked out of their home. So for evictions that are based on non-payment of rent from that period from March 2020 to March 2022, the tenant, if they're in an eviction case, even if there's already a judgment against them, they can submit to the court proof that they've been approved for rental assistance. And it has to be for rental assistance for the rent that's demanded in the notice. However, if they were approved for part of that rent and then the tenant can provide the remaining rent in full, then that should be sufficient. And what happens next is that if the landlord, essentially if the landlord hasn't gotten paid yet, the court will continue to set follow-up hearings. And if the landlord has gotten paid, then the court can dismiss the case. And this also means that the lockout can get postponed through one of these hearings. So this is a really powerful tool. And it's a really good reminder that one thing tenants can do to protect themselves is to apply for rental assistance. Now, this tool I just described, it only applies if the tenancy was established before October 1st, 2021. If it's a brand new tenancy, then it's not going to apply. Additionally, there are some changes to how the court issues summonses during this time period. So again, Rachel talked about how when the court issues a summons, that's what triggers the 5-day time period for the tenant to respond. And that's really what gets the whole eviction case in motion. So right now, between October 1st, 2021 and March 31st, 2022, the summons doesn't just get issued automatically for non-payment of rent cases from this March 20 to March 2022 period. The summons, as long as the tenancy was established before October 1st, 2021, there are additional things that the landlord needs to provide in order to get the summons issued and really start the 5-day timeline and get the case in motion. So if it is one of those tenancies before October 1st, and it's a non-payment eviction, the landlord has to submit either a verified statement that they have applied, the landlord has applied for rental assistance, and that application got denied, and they also need to attach a copy of that denial. The other option is that they can provide a verified statement that basically they have applied for rental assistance And the rental assistance program hasn't responded to them. And the tenant also hasn't provided any sort of communication, showing that they have applied for rental assistance. There is a 20-day waiting period for, between when the landlord applies sorry, I apologize. There's a 20-day waiting period for after the tenant gives a 3-day notice. Either it has to have been 20 days since then or since they applied for rental assistance. Additionally, note here that the landlord, part of what the landlord has to certify is that they haven't gotten any communication from the tenant that they got a rental assistance application, that they've applied, that their application is pending. So what that means is that if the tenant wants to protect themselves from a potential eviction lawsuit, it's the best thing the tenant can do is tell the landlord, I have applied for rental assistance, I have a pending application. And that should hopefully freeze the eviction and keep the court from issuing a summons. Another thing I'll just note is that you can tell through both of the options that the landlord has to get the summons issued, both of those require that the landlord has applied for rental assistance. So in theory, a landlord shouldn't even be getting the summons for a non-payment case where the tenancy was prior to October 1st, if they haven't at least tried to apply for rental assistance. And then again, just a little bit of explanation about the rental assistance program. This hopefully is familiar by now, but the rental assistance is it's federal money that has been provided to the state of California and to local governments. In West Hollywood, the program, West Hollywood tenants apply directly through the state through housing.ca.gov or housingiskey.com. The rental assistance program provides financial assistance to what's called eligible households, and that can be for rent or for utilities. The rental assistance, the maximum is 18 months, beginning in April 2020. So potentially if the tenant didn't apply or was able to pay their rent for April 2020 and some other months, they might still qualify for additional months going into the future. But otherwise, April 2020 to September 2021 is 18 months. So for some tenants, they're kind of looking at that time period of 18 months, and some tenants might be able to continue to get rental assistance to cover the current months and through 2021. So it'll really depend. The best thing for the tenant to do is apply now before the rental assistance money runs out. And just want to note here, so I've talked about a lot of different non-payment eviction protections. They're at different stages of the eviction process, whether it's the notice, getting the summons issued, or even once there's a judgment, preventing the judgment from being enforced, preventing the tenant from being locked out. So it's pretty clear that there's a lot of obstacles in that landlords have to go through to evict a tenant for non-payment of rent. And so unfortunately, sometimes we've seen that landlords might try to file an eviction lawsuit based on a different grounds for eviction. And so the state law does prevent retaliation. It does prohibit that. And so landlords can't file a case based on, say, nuisance allegations that aren't really well-founded, just in order to retaliate against the tenant who has not paid rent between, March 2020 and September 2021. Okay, and now I will turn it over to Rachel.
Thank you, Hannah. Okay, so Hannah just talked about the status of evictions based on non-payment of rent. So I'm going to move on to talk about other types of evictions. So as I mentioned earlier, through January 31st of 2022, West Hollywood tenants are protected by the LA County Emergency Tenant Protections. Under these protections, no-fault evictions are prohibited unless necessary for public health and safety. So for example, in West Hollywood, we see a lot of Ellis Act evictions. Those are prohibited through January. There is an exception to the no-fault eviction ban for owners moving into the property. So that exception allows a landlord or landlord's family member to recover possession of up to 2 of the following. So it's a single family home, a mobile home space, a condo, 2 units within a duplex, and or 2 units within a triplex. However, in order for the landlord to utilize this exception to the no-fault prohibition and move into the unit, certain conditions have to be met. So the first one is that the tenant has been and is able to pay the rent and does not have financial impacts related to COVID. The owner must have purchased the property on or before June 30th of 2021. And then I think most important is that the landlord or landlord's family member moving in must be similarly situated to the tenant or tenant's household member who are being displaced. So 4 characteristics here. So if a tenant or tenant's household member is at least 62, the landlord or landlord's family member must also be at least 62. And this applies to a tenant or tenant's household who is disabled. The landlord or landlord's family member must also be disabled. This applies to a tenant or tenant's family who has a terminal illness, or a tenant or tenant's household member who is low income. So a lot of conditions have to be met in order for the landlord to utilize this exception to the no-fault prohibition. Additionally, under the county protections, a tenant may not be evicted for nuisance or for unauthorized occupants or pets whose presence is necessitated by or related to COVID-19. And lastly, under the county protections, a landlord can't evict a tenant on the ground that the tenant has denied entry into their unit by the landlord. But there are certain exceptions here as well, where the entry into the unit is to remedy or fix a condition that endangers or impairs the health or safety of the tenant or another person in the vicinity, like a neighbor, or where the tenant is causing substantial damage to the unit. So those are the exceptions to that no fault, that you can't be evicted for denying entry to your landlord. Under the county protections, there are also strong harassment and retaliation prohibitions, which include a long list of prohibited acts on the part of the landlord. And if the landlord engages in such behavior, it can result in civil and criminal penalties. And it also creates an affirmative defense for the tenant if there's an eviction lawsuit. The list of prohibited behavior is pretty similar to the list, the prohibition of tenant harassment that exists under the West Hollywood Rent Stabilization Ordinance. It includes things like interrupting, terminating, or failing to provide services required of the landlord, failing to perform repairs, abusing the right of access into a unit, abusing a tenant with offensive words that are likely to provoke a violent reaction. So if you compare the prohibitions under the county to the WeHo RSO anti-harassment part of the ordinance, you'll see there's some similarities there. Okay, let's next talk about lockouts. So during periods of the pandemic, the Sheriff's Department was not conducting lockouts, but they are doing them now. So as we discussed when we talked about the overview of the eviction process, before a lockout occurs, the sheriff posts a 5-day notice to vacate on the tenant's door. And if the tenant is not out in those 5 days, the sheriff can physically remove the tenant from the unit. But it's important to point out that a landlord can't use other means to evict a tenant. They have to go through the court process. So they can't do things like you can see on this list, shut off the utilities, remove doors or windows, or remove the tenant's personal property. They are not allowed to do that, and it's not legal for them to do that. They have to go through the court process. Here's the information for tenants to contact us, the phone number, the email address, and then also we have a online booking appointment service where tenants can actually sign up for appointments to meet with us either over Teams or over the phone. And I think that's it. And we're happy to answer any questions that you all may have.
Thank you. Commissioners, any questions?
I have a question. I'm not sure if you can see us or not. So
Yeah, I can see you now. I can't see everyone though. So
okay. First of all, thank you, all three of you, for that presentation. Very helpful and informative, and I know it gives me a much better idea and understanding of what it's supposed to look like. There at the end, you spoke about only the sheriffs can lock an individual out of their home. What happens, I mean, I know it has happened in the past because it's happened to a friend of mine. What should one do if they come home and their landlord has decided to take back the property and lock them out or prevent them from going into their apartment? I mean, should they call the sheriff's department or?
Yes, so sorry, I wasn't sure Rachel was that she was unmuting. So the tenants has a couple of options. Unfortunately, I'll admit that none of them are really great. None of them are like foolproof options, because tenants that are in this situation where landlord has already locked them out, they can be at a disadvantage when they call the police. One option is to call the police, but we don't. Unfortunately, sometimes it's like the tenant's word and the landlord's against the landlord's word, and it might not. It might be that the police don't fully understand the situation. Sometimes that might happen, but I think definitely the tenants, especially if they have been threatened with a lockout in the past, if there's a lot of tension between the tenant and the landlord, and they anticipate something like that happening, it definitely helps if they have something on their person, a lease or some sort of proof that they do have the right to live there, that they should keep that with them in case they need to show it to to the police or anyone, and hopefully that will help. Another option too is we often connect our clients with tenants unions. That's something that we might suggest, and of course they should get legal assistance. And if this happens in West Hollywood, this would be an appropriate time to contact us, right, Rachel?
Absolutely.
Thank you.
And we work closely together with social services, which have often stepped in to help because they have a relationship with the West Hollywood sheriff. So we have often been able to stop the lockout if it was in the process, just by intervening. And as long as there's no court order issued, I think we can do so with relative success.
Thank you.
Commissioner.
Yes,
Sorry, I just want to add I apologize. Just wanted to add to that the tenant also maybe has the option of just using a locksmith and getting back in. And that's, again, another reason why it's important to have that proof that you are supposed to be in the unit, that you do have that right.
Yes, thank you, Madam Chair. First, I want to thank you for being here, and thanks for the very informative, very interesting presentation. I think it was really important for us to see the eviction process, how it goes, and the changes in the unlawful detainer process currently, and also the protections that the tenants have under local, county, and the state protections. So, and I want to also say that your agency, Bedzedek, has been really important. Has been very vital agency and a partner to the city of West Hollywood. So I think we're really fortunate to have you as the agency that would provide services to our city. Very, I had personal relationship years ago with Bedzedek, and I personally know Ms. Chesnock, Ala Chesnock, a wonderful staff attorney as everybody else. Very responsive staff, very knowledgeable, and staff that cares. And I think that is important for West Hollywood, because everybody in West Hollywood, whoever involved in the public service or the local government, we do care about about our community and about our residents, and especially in these tough times. And having you as the service provider for the city, I think that's very important, and I really appreciate and thank you for wonderful work that you do for the city. So now, Ms. Livia, you mentioned that when you spoke before, there were 17 calls, 17 inquiries you received since October 1st, and these are eviction-related inquiries, right? So do you anticipate, I know nobody can predict the numbers and nobody can predict the future, but do you anticipate any spike in the eviction complaints? I wanted to know if there's any stats and how many cases you currently have or you're dealing with, so if you can provide anything like about the statistics.
So I think that once people exhaust their state rental assistance, like Hannah said, if you have been receiving state rental assistance since the first month that it was available, April of 2020, you've exhausted it by the end of September. And unfortunately, people are, because this pandemic is ongoing and it's not over yet, people are still out of work and not making what they made before the pandemic. So they're going to have very little recourse once they've exhausted the state rental assistance, and their landlords are able to, get a denial because they've used the 18 months. So I do think that we'll see a spike in evictions based on non-payment of rent. A lot of people have not fully, I don't know the word, but a lot of people are in the same position that they have been for many months. And then I think that some of the notices that were not based on non-payment of rent that we've just received, Allah's fully aware of them because we talk about all of our cases constantly. Yeah. But I think some of these that we've received last week and this week are certainly going to create an uptick in eviction cases. It's been a little quiet in WeHo, knock on wood, but I don't think that's going to remain the case based on what we're seeing this month. There's been a ton of notices.
And you see it because you provide also services outside the city of West Hollywood, and you see how things are being developed. So probably it's going to happen in West Hollywood also. And comes January 2022, January 22. What is it that the tenant should know about what's going to happen or what could happen, and what will be protections in starting January 22 for the eviction? I mean, regarding the evictions for non-payment.
So the protections that Hannah discussed, and Hannah, you can chime in. Those protections where the landlord has to verify certain things under penalty of perjury in order to get a summons, those are in effect through March of 2022.
22, okay.
Yes. The county protections are in the no fault eviction protections are in effect through January 2022. But of course, West Hollywood has the rent stabilization ordinance. So, you know, a landlord still has to have a reason to evict a tenant, and they still have to abide by the rent stabilization ordinance. For non-payment of rent, I think it's going to, unless further protections are passed, I think it's going to revert to how it was pre-pandemic. I mean, Ala or Hannah, you can add to that.
And maybe Hannah can, if you want to respond, of course. And also, what is the rental debt that people hear about it? And we heard also that you know, in March 2022, the evictions for, as far as maybe you can correct, that there wouldn't be evictions for non-payment of rent. The payment of rent or whatever the rent that tenant owes would be pursued through the small claim courts, but that landlords would not be able to evict. What is it true, or what part of this is true, if any?
Yeah, I think, yeah, let me try to think about all of that. So I think there's a few different things going on. So one is, I think I'll share my screen again, just so we can go back to some of the state law, because I know that the state law portion was particularly dense. So going back to you know, the recap and the current protections. So it's true that from the period of time from March 2020 to September 2021, that's when there was this framework where there was a declaration. If the tenant submitted a declaration and they made the 25% payments, if applicable, by the end of September 2021, that they were permanently protected from eviction. And so that means that, you know, if there's anything left over that they haven't paid, you know, that the other 75% of the rent, perhaps, then the landlord can still come after them in small claims court to try to get that money, but the landlord can't evict them. They're permanently protected from eviction. So that is still going to be true, you know, even come, you know, March, April 2022. What is going to change starting in April 2022 is, you know, some of these other protections that we've talked about tonight. So there's what's called this recovery period from October 2021 to March 2022. For those 6 months, there are these certain protections that apply, and you know, we discussed them earlier, but just to kind of recap, there's this way that even if a tenant has already gotten a judgment, if they've been approved for rental assistance and then they can pay like whatever amount might be remaining, they can essentially, they can postpone the lockout. They can eventually get the court to dismiss the case if the landlord gets paid. So that's one protection that is, as far as we know, is not going to continue after March 2022. And then this change to the summons process, where the court just doesn't issue the summons if the landlord hasn't already, you know, either provided the statement of denial or the statement that, you know, they've tried to apply and tenant and rental assistance program are unresponsive. So for those protections, those are going to be in effect through March 2022, but you know, not, as far as we know, not after that. And then I guess I'll just point out too that personally, I don't know when the rental assistance program, when the state program is expected to run out. And, you know, at some point, if that happens, that's obviously going to impact some of these protections. And, you know, it'll mean that tenants, if if there's no money, the tenants aren't getting approved and they can't use these protections. I think we'll have to see exactly how that plays out.
Thank you.
Commissioner Maggio, you had a question?
Yes, either to Hannah or Rachel. Once a landlord gets a ruling from the court to evict, then the tenant has 5 days to answer to the court. Do we know, or do we have any idea how long that process is? A month, 2 months, 3 months? Or I can't believe you could get an immediate court date. I guess that's the question.
Rachel, do you want me to?
Yeah, go for it, Hannah.
Okay, great. So just want to address, I think what you said was once the court gives the order to evict. So I just want to go back to this slide about the process, because it's a little bit, there are a lot of steps, and I just want to be clear exactly which steps we're talking about. So after the notice stage, that's when the landlord files a complaint in court, and then the court issues a summons. And as I mentioned earlier, that process where the court issues the summons, right now there are some restrictions on that. So some cases might get frozen at that stage if the landlord hasn't followed everything. But I think your question is like once the court does issue the summons, and then there's a 5-day timeline, is that correct?
Yes.
Yes, so then, and so the question is specifically like how long it takes to get a court date?
Yes, do we have an idea how long then it will take to have a final conclusion or an answer from the court?
I'm sorry, I wanted to interject just to clarify. Is it a non-payment of rent case, or is it a different kind of case?
A non-payment.
Because if it's
non-payment.
Okay.
So right. I'll just say that in all West Hollywood cases go to the Santa Monica courthouse. So it varies, and cases were taking longer to make its way through the court system during the pandemic, and I think things are kind of speeding up now. But after the tenant answers, the landlord then has to ask for a trial date, and Santa Monica sets the trial date about 3 weeks after the landlord requests a trial date. But usually the case isn't resolved by that first court appearance. So I can't say exactly, but several months for a case to get resolved. Hannah, Alla, would you agree with that?
Yeah, go ahead, Alla.
No, I was going to say I definitely agree, because there's all these MSCs and settlement conferences and discovery, and we tend to did just have a case where everything kind of moved by the book, and the case, the trial was set for just a couple, 2 to 3 weeks out, very soon. But it was almost understood that it was going to be continued, and it got continued into January. So we have our first appearance only set for January. Just to give you an example.
So it could take months, literally months, to really evict someone once it gets to the courts, because you have to get that court date, and that could take months.
I do want to clarify one thing. So first of all, the process is obviously, as Rachel said, it's much quicker if the tenant does not respond. Then there's kind of this fast track where the tenant loses automatically, and then the sheriff can post that notice to vacate. The other thing is that it depends whether there is a jury trial demanded or not. That can change how long the process takes. And this is just kind of another reason to really underline why it's so important that tenants get legal assistance, because if they're representing themselves, or if they don't even enter the case at all, if they do nothing, they're really going to end up in a bad situation. And, even if they do figure out how to file an answer by themselves, they might miss their opportunity to request a jury trial. So the process will, I think the process might, take different amounts of time depending on how all of those things play out.
Thank you.
Are there any other questions from commissioners at this time? I can't see all of you, so if so, please speak up. Okay, I think that's it. I have a question then. First of all, thank you so much for this. It's really been helpful, and I appreciate all of you coming and also all of the work that you do for the community. Is it possible, what you've been sharing with us on our screen, is it possible to get that information, other than having to watch this meeting again, where we could have that on hand to refer to? Like these in maybe an email format, or just the charts and so forth that you put up here. If it's possible to get that, I think that would be helpful.
Sure, we can send that.
That'd be wonderful, I think. Thank you so much again for coming. Are there any other commissioner comments for the presentation or questions at this time? Okay, thank you very much. Appreciate it.
Thank you.
Thank you so much.
Thank you.
Thank you. Okay, at this time, do we have any items from staff?
Thank you. Just following up on that last question, Chair, I think we actually have a copy already that was sent over today. So if any commissioner would like a copy of the presentation, staff has that available.
Wonderful.
And Roger can distribute that to anyone who wants it. Also, I will get more clarification on the December 23rd meeting. We'll do another poll of the commissioners to see whether or not that one can go forward or not, and we'll know for certain by our next meeting in December. I too would like to thank Alla, Rachel, and Hannah again. I know how hard they work and how busy they are. So to come out here tonight and give us this really comprehensive presentation is deeply, deeply appreciated. So thank you for that. And also just following up on one thing that came up during their the question and answer period during their presentation about lockouts. Another resource is the Rent Stabilization Division. Fortunately, it is an uncommon occurrence. I have only seen it happen perhaps twice in my 11+ years with the city, and we've addressed it if we found out about it, and it's a prosecutable offense. So the message to landlords is do not do that. And the message to tenants is if it happens to you, please contact the division. Of course, contact the sheriffs, but contact the division and contact Bexetic, contact all the available resources. And of course, we can be reached at 323-848-6450 or rsh@weho.org. And finally, I'd just like to wish everybody a good holiday next month, and looking forward to seeing you in December. Thank you.
Thank you. Commissioner Maggio, you had a question or comment?
Yes, to the manager. So we have no meetings in November, and what would be the possibility of moving the December 23rd meetings to the last Thursday of November?
The last Thursday, well, it's not a regularly scheduled meeting date.
Or, well, we meet the 2nd and 4th, isn't that correct?
Unless I'm mistaken, the 2nd and 4th Thursdays of November are holidays. That's why we're not going to be having meetings.
All right, I see that. Okay, thank you very much.
Okay, no problem.
Okay.
All right.
Do we have any public comments at this time, Mr. Secretary?
We have no public speakers.
Okay, thank you. Items from commissioners. Commissioners' comments. And yes, Commissioner Maggio, and then Commissioner Kerpes, please.
I did not want to leave without wishing everyone a happy Thanksgiving. And may you enjoy it. And may this be even the best. Happy Thanksgiving.
Thank you. Commissioner Kerpes?
I will say the same. Happy Thanksgiving to everybody. And happy Veterans Day. I just also wanted to thank Alla, Jennifer, and Rachel for, or Alla, Hannah, and Rachel for coming this evening and giving that presentation. And in terms of the lockout as well, Mr. Hollov, is it possible that maybe because we know that there are, even though that does happen rarely, lockouts shouldn't happen, but and when they do, it would be rare. Would it be possible, especially since the sheriff's department is the department and the deputies that would be carrying out, I know they are different deputies, but the department itself is the department that works with the courts on lockouts, that maybe a memo be sent over to the captain just to remind people what to do? In the situation that I'm aware of, the sheriff's deputies were excellent. In fact, that's who my friend called. They called the deputies. The deputy instantly knew exactly what to do and knew what questions to ask to resolve the matter. But I could see in a situation that, you know, if somebody just having an off evening, they're not going to necessarily treat the tenant in the same way that that my friend was treated. So maybe if it's just a reminder to the sheriff's department on what to do in situations like that. So if anything happens, you know, we're a small town, it's easy for us to get that message out to the deputies. Whereas, you know, if we were part of the county or part of the larger city, it would be more difficult.
Right. We've been in communication with them in the past on this issue, but it probably has been a while since it hasn't come up. So I'm certainly happy to revise that conversation.
Thank you.
Commissioner Topchin?
Yeah, very quickly, Mr. Hollop, don't go away. Since we had the appeal and about the handrails and the evaluation, can we include that? I don't remember if we have that included because we expanded the guidelines. Maybe you can check, maybe we can include it for future cases.
Yeah, I can't remember myself if it's on the new list, but it will be there when it comes back to you.
Okay, thank you.
Thank you. Commissioner Montemayor and then Commissioner Ayers.
I just wanted to thank Vice Chair Copeland for leading us in tonight's meeting. It was a long one and you did a great job. Thank you.
Thank you. Commissioner Ayers?
Yes, I just wanted to say that I appreciate the presentation that Betzedek brought to us tonight. Thank you, city staff, for arranging for that. And I just wanted to give a shout out to another county resource. LA County has an eviction mediation assistance helpline, and that number is 833-972-0999. I believe it's overseen by the county's Workforce Development, Aging, and Community Services. So I just want to put that resource out there, and I'll say the number one more time. It's the LA County Eviction Mediation Assistance Helpline. It's 833-972-0999. Thank you.
Are there any other commissioner comments? And this time, if not, I will wish all of you a very happy Thanksgiving and November, and thank you for your patience while I was keeping Chair Mart's chair warm for tonight. I'll be happy to see him back on the 9th, but thank you so much, and appreciate all of you, and happy Thanksgiving. And with that, we will adjourn until our next regularly scheduled meeting of the Rent Stabilization Commission, to be held on December the 9th, 2021 by a teleconference. Thank you.
Happy Thanksgiving, everyone.
Good night, everyone.
Great job.
Oh, thank you for your patience. Appreciate it.